Welcome everyone to this new episode of the Privacy Rules Privacyespresso series, a series where we go together with our experts from all over the world deeper into specific news related to privacy, data protection, and technologies. Today, I'm pleased to be here with Tara Chan from the law firm Tanner De Witt, exclusive member of the Privacy Rules Alliance in Hong Kong. So Tara, hi, and thanks a lot for being with us today.
Hello. Thanks
Tara
for having
is,
me.
Thank you, Tara. Tara is an expert from the firm. She comes from the TMT practice, and as part, of it, she works daily on privacy and data protection. And this is what we're going to discuss together with her today in this episode, because there are some news related to data localization, in particular in Hong Kong. So I think that we can immediately move on the topic of the data together with Tara. So Tara, can you give us, first of all, quick overview on which are the data localization requirements and the residency requirements in Hong Kong?
Thank you, Alessandro. So we have just recently issued a guidance in respect of Hong Kong law, data localization and data residency requirements, and also talking about storage requirements. So I'll first talk about data localization and residency. It is a common topic right now in respect of personal data around the world. There are many jurisdictions that have specific requirements. However, Hong Kong in general, we do not have data localization or residency requirements. However, just to explain the framework of Hong Kong data privacy law, our legislation is called the Personal Data Privacy Ordinance, or PDPO. We have specific provisions under there that touch on data localization and residency requirements. So for example, under the PDPO, a data user, or is also referred to data controller overseas, they must notify data subjects on or before collection of their personal data the potential classes of transferees. So this can be transferees from within Hong Kong or outside Hong Kong. So that's where we talk about there's no specific restriction on setting out whether data has to remain local or it can be transferred overseas. We only have to notify the classes of transferees that may be transferred to. And the second point that I want to talk about is also on or before collection, the data user must inform the data subject of the purposes of collection or the uses of the personal data. And transferring data is considered a use of the data. So if you, as a data user, are planning to transfer the data outside of Hong Kong, then this must be notified to the data subject on or before collection. Also, the PDPO touches on if a data user wishes to transfer the personal data to a new transferee that was not previously notified, or use the data for another purpose or use, then it must obtain the prior express consent of the data subject before doing this. So these are the points that touch on data localization and residency requirements under Hong Kong law.
Perfect. Thanks a lot for this brief overview and this clear structure that has been created and to comply with. So to have a look at, of course, if you are having data and exchanging data in and out of Hong Kong. In this regard, my next question would go a bit deeper into this. So are there any specific, because this happens in many other countries, so are there any specific data storage requirements in respect of different sectors or different types of data that the PDPO is speaking about?
Yes, there are. So talking about data storage requirements, so under the PDPO, there's the general requirements that you're not to keep personal data longer than is necessary in respect of the purposes for collection, and you need to protect the personal data from unauthorized or accidental use, access, processing, loss, erasure, etc. So typically a data subject has to, if they're wishing to engage a data processor, they have to enter into contractual or other means with this data processor to ensure the two principles I mentioned above in respect of storage. So touching on different types of data, I know that the type of personal data that often comes to mind is sensitive personal data. So under Hong Kong law, we don't have such a concept of sensitive personal data. However, the Privacy Commissioner of Hong Kong has issued certain codes of practices or guidance notes setting out that specific types of data may be considered more sensitive than other types of personal data. And these types of data are, for example, Hong Kong identity card numbers, personal identifiers, consumer credit data, biometric data, health, finance, and geolocation data. So all of these types of data, we don't have a separate category of personal data. However, there are specific provisions that are recommended or should be followed in accordance with the Privacy Commissioner of Hong Kong. So the Privacy Commissioner, for example, will issue codes of practice on how to handle Hong Kong identity card numbers. So codes of practices are not legally binding. However, a breach of a code of practice would give rise to a presumption against the data user in legal proceedings that the PDPO was not complied with. So they're not legally binding, but very strong recommendations. So for example, the code of practice for Hong Kong identity cards will set out exactly when, for example, a data user should be collecting the data, what are the necessary types of means to collect Hong Kong identity card numbers, when it should be erased or the uses of such identity card numbers, how long it should be kept. There's some kind of system for purging such data, and also the extra security measures necessary in place for such sensitive data. So according to the Privacy Commissioner, the level of protection should be proportionate to the sensitivity of the personal data in question. So because, for example, Hong Kong identity card numbers or biometric data is considered more sensitive type of information, then a higher level of security and protection is necessary for this type of data. So going into different sectors of who control personal data. So looking at, a typical company and company records. So under, for example, the company's ordinance, accounting and tax records must be stored for at least 7 years for a company. And, there can be certain personal data information in such records. So then this personal data must also be kept for at least 7 years, and respect of also employment records and information that must be kept for 7 years. So that will include Hong Kong identity card numbers and then other types of personal data such as bank account information. So this must be kept for at least 7 years. So under the PDPO, there's no time frame set out. It's only to be kept for as long to complete the purposes of collection or as necessary to complete the purposes of collection. However, under other types of, for example, companies, laws, there is a necessary timeline to keep such records for at least 7 years. And as for the finance sector, so there are, for example, codes of practices in respect of consumer credit data and what entities in the finance sector, how they control, store, and protect such consumer credit data, personal information. And then looking at specific regulatory bodies and regulated entities. So for the Securities and Futures Commissions, who control licensed entities, they have specific regulations in place in respect of such licensed entities to ensure compliance with the PDPO in respect of how financial information is handled, how it's stored, and how it is protected and finally erased. And this is to ensure that such financial information and personal information that's included in such financial information is sufficiently protected. So, for example, the Securities and Futures Commission, they suggest that there be certain officers within the licensed entity that are fully aware of the requirements under the PDPO. And then also looking at authorized institutions that are governed by the Hong Kong Monetary Authority. So what's interesting is the Hong Kong Monetary Authority have issued a guidance note on authorized institutions, data users who wish to engage cloud computing service providers. So there's a whole guidance note on how exactly the personal data of these authorized institution is to be handled by such cloud computing service providers. And the authorized institutions have to ensure that there's some kind of effective governance framework to oversee such cloud service provider. They have to conduct proper due diligence before and throughout the engagement of the cloud service provider to ensure that the data will be sufficiently stored and protected. And lastly, the HKMA also wish to ensure that they have supervisory access of the relationship between the data user and the cloud service provider. So they insist that certain clauses be inserted in the service agreement between the authorized institution and the cloud service provider. So that's quite an interesting point to note. And under this guidance note, it also provides specific requirements under storage and protection using a cloud service provider. And then lastly, talking about the health sector. So there is an electronic health record sharing system whereby the public health system shares information with the private health system in Hong Kong. So the Privacy Commissioner of Hong Kong has also issued a guidance note in respect of how to deal with health personal data that's being used and shared and stored on this system. So it just provides healthcare providers with reasonably practical steps on how to ensure that personal data is protected on this system and how it is stored, and to ensure that, some healthcare providers only provided such information on need-to-know basis, and also to ensure the security of the information by such healthcare providers. So yes, those are all the aspects in respect of data storage requirements under Hong Kong law.
Okay, thank you very much, Tara. And this, sounds pretty complex, meaning that we have various sectors that comes in that have different requirements, and on the other side you have different definition of type of data that might be clearly stated on a law but sometimes not. So definitely a type of sector where you would like to be supported by an expert, I believe. So thanks a lot for giving us an overview, and of course I would invite everyone to contact you and the team of Tanner De Witt for any need in Hong Kong for sure. Just quickly at the end, because we are running out of our time, do you have any tip for people that have to handle data in Hong Kong in relation to this specific topic, even just 2 or 3 that you think they should be really focused on?
Tips I would say is maybe if you're looking at collecting personal data, looking at the Privacy Commissioner's website, there's very useful guidance notes, brochures, pamphlets to have a look at, just to get a general sense on the requirements. It's very user-friendly. And second point is also the Privacy Commissioner is quite reachable. So if you have any types of questions that you want a quick answer to, you can try calling their general inquiry hotline to see if they can assist.
Okay, those are very interesting ones, I would say, and not common. I mean, meaning that not all DPAs or authorities are, so easily reachable. So that's very good to know. Tara, thanks a lot for your time. We are running out of it. It was a pleasure speaking and listening and learning in particular from you. Of course, I would also like to thank all our listeners for being with us today. So looking forward to the next Privacyespresso episode with Tara, and of course with the Privacy Rules member. Thanks a lot to everyone. Thanks, Tara, again.
Thank you.